want to wrap up as early as possible. I'm going to refer to 366.12a GST, then go to entry 8 and go to entry 33, and I'm finished. Please come to article 366.12a. And then your lordship will.
Article 366.12a.
Yeah, your lordship, there's a definition section, as the lordship knows.
Yes.
And they have defined GST by the 101st Amendment. Yes, 1 second.
Any tax on supply of goods
Indirect,
or
yes,
services or both,
yes.
except taxes on the supply of alcoholic liquor for human
consumption. Now, lordship will note that taxes on the supply of human consumption. So now that central excise duty, state sales tax, all is subsumed into GST, which becomes a concurrent levy, both center and state. Lordships, Mohit Bindral's lordship said that. What is left for the states is alcoholic taxes on supply of alcoholic liquor for human consumption. So these taxes on the supply of alcoholic can be by way of excise duty or other imposts. Now, if your lordship just goes to entry 84 for a minute, the pre-amended entry 84. Entry 84. It will be in the footnote. Now, please see the new entry after the 101st Amendment. Lordship got it? Yes. Duties of excise on tobacco. I'm seeing the footnote. Now, my lordship, on tobacco and other goods manufactured or produced in India, except alcoholic liquors for human consumption.
That was sorry, you're referring to entry?
Entry 84, my lord, old entry.
84, prior to amendment.
In the list one, sorry, my lord, at the footnote,
yes.
Duties of excise on tobacco and other goods manufactured or produced in India. But the unique thing that tobacco is an agricultural product. All excise duties on manufactured goods. Tobacco is the only case where it is levied on an agricultural product. But I'm on except alcoholic liquors for human consumption. That lordship will now come to entry 51 of list 2. Which is the taxing part. Entry 51 of list 2. Duties of excise on the following goods manufactured or produced in India, in the state, and countervailing duties at the same or lower rates on similar goods manufactured or produced elsewhere in India. So, my lord, if liquor is imported from another state into one state, they can levy CVD, just as on import from other country, we can levy CVD.
Right.
That is to balance, because it can't be that one state levies 20% tax, other state levies 10%.
Right.
Then becomes an arbitrage for tax evasion. So they neutralize it. So that can be a countervailing duty. Duties on excise on the following goods manufactured: alcoholic liquors for human consumption. So
what is taken out of entry 84 is introduced in entry 51.
51. So what happens? Yes, except. So the concurrent power under Article 246A. Article 246A says tax on supply of goods or services. Right. That is defined in 366.12a.
Yes.
Just as after the 46th Amendment, tax on sale of goods is now defined in 366.29a, like that.
Right.
So the net result is, today, if it is an alcoholic liquor for human consumption, call it potable alcohol, call it every alcohol, I would humbly submit that the proper way of interpreting, for your lordship's stand consideration, is to take it in the reverse. Everything except denatured spirit will be alcoholic liquor for human consumption. Because unless it is denatured, it is alcoholic liquor for human consumption.
Everything except
denatured spirit. Because since your lordship is sitting in 9 judges, we don't want another round of litigation. Is it alcoholic liquor fit for human consumption? At what stage you levy, etc. And the reason, sorry. Lord, why I say this also is because of, on this tax aspect, Lord, because of this, we have to also see the economic consequences of what we hold. This is Sikri refers to Richard Posner's theory of law and economics having an interplay. Suppose your Lordship says, as held in synthetics and chemicals in para 85, they say it should be fit for human consumption, para 65. Then what happens is state has no power to levy any excise duty unless it's a ready-made whiskey, rum, gin or beer. At the ENA stage, it has no power to levy. That ENA is actually for human consumption. Part of it becomes unfit by adding a denaturant. And why do you add a denaturant? Because the state says, if I'm going to lose my revenue, you better make it unfit for human consumption, then you clear it. So my humble request is, keeping in mind the interplay of law and economics, if a Lordship takes the view that it should be fit for human consumption, it will have deleterious effects on the state finances, particularly after GST, where as part of our new fiscal federalism, the taxing powers of the states have been drastically reduced. Today, only major sources, alcohol, potable alcohol that is, and petroleum products. And Lordship has interpreted 279A4. They say that once the GST Council decides to bring it into the levy of the net of GST, then state lose the power. But today, the main source of real alcohol. So my humble submission is, if we use the word fit for human consumption and take it to that stage, it will have an extremely adverse impact on the taxes of the states.
In fact, the word fit is not there.
Not there.
For
Is it
human
there anywhere?
consumption.
Not there. Not
Is it there anywhere?
No,
Fit
no,
word?
no, not fit for.
So,
I checked whether there is anything.
By interpretation,
For human.
otherwise it is for.
Yes.
So it is capable of.
Yes. Actually, I tried to do a legal search fit for. I got some 6,000 entries. Wherever there is fit and for, it is showing up. So it became very difficult. Even statutory provisions, I could not say. There's no, only Anwar Khan says that consumption doesn't mean final consumption. As long as the goods can be consumed, it is enough. I'll give you an example, Manoj. Suppose you say rice. Now, rice by itself is for human consumption, but till we make it into put into a pressure cooker and make it into rice, or wheat is converted into flour or atta or maida, it is still wheat. It is still for human consumption. So in the same way, ENA, in my chart, after the secondary process of distillation, first substrate, rectified spirit, ENA. Then we branch out into drinkable or industrial. So my humble request is, keeping in mind 366(12)(a), the power of the states to levy tax should be on extra neutral alcohol. Whatever is not
We are not
denatured.
really, in that sense, dealing with tax per se under entry 51, are we?
No.
We are dealing with the ambit under entry 88. Your contention is that we are entitled to levy fees.
No, I'm on a different point. I'm saying that I have to get over the synthetic, because synthetic 7 judges say it has to be fit. In para 65, they say,
Yes.
it is fit, it's like a beverage. They use actual, and they put it in italics with emphasis. Till it's a beverage, state has no power to levy tax at all. That, in my submission, is too extreme from the state's perspective. And it may lead to a conundrum, because so, my lord, sorry, may I continue? So, my lord, this is the request.
For human consumption is that it may be eventually destined for human consumption.
It has the potential to be
Potential
to be meant for human consumption. That's the point. Now, my lord, I go to entry 8 and entry 33. Entry 8, my submission, my learned friend has elaborately discussed the whole point. My submission is entry 8, as your lordship knows, is not subject to. But my lord, just Nagaratna asked the question, what is the interplay of 246, 2 and 3? There I had my
246(1). 246(1) also.
246(1) also. Please see, my lord, 246(1), 2, 3. And I would request your lordship to read it in the context of 254. 246(1), yes. notwithstanding anything contained in clause 2 and 3, Parliament has exclusive powers to make laws with respect to any of the matters enumerated in list 1. 2. Notwithstanding anything in clause 3, Parliament and subject to clause 1, the legislature of any state also have the powers to make law with list 3. 3 is very important from my side. Subject to 1 and 2, the legislature of any state has exclusive powers to make laws for such state or any part thereof with respect to any of the matters enumerated in list 2 in the 7th schedule. So Lordship will kindly see the rule is exclusive power. In the concept of a federal structure, exclusive power is there. And my humble submission is, unless that legislative entry uses the word subject to, the power of the state legislature should be plenary.
But subject to really makes it clear that the power of the legislature of the state is, in that sense, I wouldn't say subordinated to
Parliament.
but is
One.
subject to the power of
Yes.
Parliament. And
Very interesting. Very interesting. Now, let's take a law with regard to entry 8. Manufacture, production, possession, transport. Intoxicating liquor. That is to say, manufacture, production, possession, transport, sale. This is given, exclusive power is given to the state. Now, my submission is, if a lordship now reads 254, I am saying the question of competence. Just because Parliament is supreme, it does not mean it can make a law which has been exclusively given to the state.
undoubtedly.
Undoubtedly. So, yes, that's all. So 254, Lordship has got the point, so I don't belabor on that. Please see 254. I'm saying, I'm requesting Lordship to read 246(1), 2, 3, and 254 as an overall scheme. 254(1). However, I'm not going to 254(2) because entry 8 is not in the concurrent list.
Correct.
If may I read note 2, sorry. Yes.
The word subject to clauses 1 and 2.
Yes.
Does that mean that where Parliament has undoubted power to make a law and has made a law in exercise of its jurisdiction to make a law on the union list, the state also has a power to make a law on a subject which falls in the state list?
Yes.
Both have
Yes.
powers and both are acting within their realm.
Yes.
The law, nonetheless made by the legislature of the state, ought not to entrench upon the law made by by Parliament.
True. But I'm going in one other way. Repugnance will come where it's a law validly made by Parliament. There is another law made by the state. Two can't collide and coexist. Right. Then in that case, supremacy goes to Parliament. So if the two laws are colliding with each other, then Parliament law will supremacy. I am requesting a lordship to interpret entry 8 to mean, please see 254(1). If any provision of law is made by the legislature of a state is repugnant to any provision of law made by Parliament. But what law made by Parliament? Not any law. Please see the next after the comma. Which Parliament is competent to enact?
With respect to one of the matters enumerated in the concurrent list.
Concurrent list. No, there my submission is after comma or to any provision of an existing law. My submission is the first part, that is up to Parliament is competent to enact, can be a list 1 versus list 2 law. Then there is a comma. Yes. Or to any provision of an existing law with respect to any matters enumerated in the concurrent list. Yes. Then subject to. So now the second part, concurrent list, or to any provision of an existing law made. Please see this now. I'll put it this way. There is an existing parliamentary law. That existing parliamentary law is with respect to a matter in the concurrent list. Any law made by the state will be repugnant, will be void to that extent. I'm not on an existing law. I'm only trying to interpret the scope of list 2. I'm trying to say the words between the two commas, which Parliament is competent to enact. If entry 8 has given exclusive power to the states in the context of manufacture, production, possession, transport, sale, Parliament has no competence to get into intoxicating liquor on those fields. Because it's not any law made by Parliament. It should be a law which Parliament is competent to enact. And my submission is that non-obstante clause only talks of a law, competent law of Parliament. Suppose tomorrow Parliament makes a sales tax law. It's not competent to make it. Then you can't say no, Parliament in the federal structure is supreme. That's the submission. So my humble submission is these words are very important, which Parliament is competent to enact. I have also this theory that occupied field should not be necessarily restricted to concurrent list.
No, therefore, the scope and ambit of this expression in entry 8, intoxicating liquor, is again important.
Yes.
Because if there is something beyond intoxicating liquor,
Yes.
then it can be read in the first part of
Yes.
Article 254,
Yes.
read with subclause 1 of Article 245, 246.
Yes. But my answer.
They go together.
Yes, my answer to that is this. Now, intoxicating liquor has not been defined.
Yes.
It has not been defined. What do we do? Mr. Sirwai goes into various aspects of different types of competence. Gannon-Dunkley, the test is the classic test. Suppose a word is not defined in the Constitution. Then find out if that word is nomen juris. If that word has got a definite connotation over a passage of time, then adopt that. Therefore, what happened in the Gannon-Dunkley's case? The Madras government, then Rajaji's government, amended the word sale to include works contract. That was challenged. And incidentally, as brilliant as the Supreme Court judgment, the classic Madras judgment is equally good, Justice Satyanarayana's judgment. What they say is, you have got the power to tax sale or purchase of goods. Sale is not defined. Then can you say state government can say sale includes works contract? What Justice Venkatramaya says in Gannon-Dunkley is, sale is not defined. But sale is nomen juris because by tradition, the Sale of Goods Act, which was earlier in the Contract Act, sale basically means it should be goods, consideration should be in money, and there should be transfer of property, buyer and seller. If those three things are there, it's a sale. In works contract, that is absent. So he said, you can't expand your taxing powers by giving artificial definition to the word. In the context of intoxicating liquor, my submission is, all the acts are here. We have made a complete chart. Spirits Act 1880 says spirit includes denatured alcohol. So intoxicating liquor today, India Mica, FN Balsara, all have said intoxicating liquor includes denatured spirit, because if your lordship sees my chart, the color chart, denatured spirit is born out of intoxicating liquor. In a sense, it's the offspring of intoxicating liquor to which denaturant is added. That's all. So you have molasses, you have rectified spirit, you have extra neutral alcohol, and then one branch goes to denaturing. So my submission is intoxicating liquor in that sense. There is no such thing as industrial alcohol coming out of somewhere. Industrial alcohol is the offspring of intoxicating liquor. And my submission is that subject to in 246(3), your lordship asked, that subject to must be a subject to in the Constitution. And a legislative entry cannot be cut down by a parliamentary law. That's why they say subject to, entry 24, lordship mines and minerals, subject to, subject to. Incidentally, in list 1, entry 32 is the only list where it is subject to a parliamentary state law in the Constitution. Now, my lord, so my humble submission is entry 8 should be read in such a way that the state's power is supreme, because tomorrow, if they want to levy a rent fee, a regulatory fee, so we should completely demarcate what is the territory, legal territory for the states. And I would submit, as the statement of object says, let the Lakshman Resha, let the borderline be the time of removal. Up to the time of removal, it is the state's jurisdiction. When it is removed, depending on its destination, it becomes a state tax or it becomes a central tax. Now it becomes a GST. Now, my lord, I go on to entry 33. Lordship will kindly see entry 33 is substituted by Article 36 by the third amendment to the Constitution. And why was it done? My lord, if your lordship kindly sees entry 33 for a minute.
They added B, C, D, E.
Yes, not just that, there was a small change. If your lordship kindly takes, I've got the old entry 33. What's that? It's just one page, so I didn't put the whole Government of India Act. Huh? It's in Tikarang.
Now use the word industry.
Yes.
The earlier one was in plural, industries.
If your lordship kindly sees where the control of such industries is, yes, your lordship is right. Lord, one thing of 33, is your lordship seeing the old act? Not? I'll see the old act and then go. Please see the old one. Trade and commerce in. So lordship can link it to 26. Production, supply, distribution of. Link it to 27 of list 2. The products of industries where the control of such industries by the union is declared by parliament to be experienced in public interest. Now, why was the need to amend it? Please come to 369 of the Constitution.
They of course also added and imported goods of the same kind as such products.
Yes. No, please see 369. One of the temporary provisions in the Constitution, 369. With the list of Lordship has got 369.
Yes.
Temporary power of parliament to make laws with respect to certain matters. Notwithstanding anything contained in this Constitution, Parliament shall, during a period of 5 years from the commencement of this Constitution, have power to make laws with respect to the following matters as if they were enumerated in the concurrent list. So they take a legal fiction with regard to specified matters, even if it's in the state list, Parliament gets power. Now, please see what are the matters. Trade, commerce within a state, in the production, supply, distribution. Again, they adopt the language of 26 and 27. Cotton and woolen textiles, raw cotton, including gin cotton and gin cotton kapas, cotton seed, paper, newsprint, foodstuffs, cattle fodder, coal, including coke, derivatives coal, iron, steel, and mica. Now, this is what's going to lapse in 1955 because it has a shelf life of 5 years. So if your lordship sees the statement of objects and reasons of the third amendment, Parliament felt it necessary that though 369 will lapse in 5 years by 1955, Parliament should continue to have control over certain essential items. That's why they came with this substituted entry of 33. Now please come to entry 33 for a minute. Lordship will note that entry 33 of list 3 Lordship will see, my lord, trade and commerce in production, supply, distribution. So there are 5 activities: trade, commerce, production, supply, distribution. Now come to A, products of any industry. As the lordship said, now it's industry, where the control of such industry by the union is declared by parliament by law to be expedient in public interest, and imported goods of the same kind of product. B, C, D are some of the items from 369. Not all.
Yes.
Not all. Because iron and steel has gone to IDR Act, coal has gone to Mines and Minerals Act. One more distinction Lordship will note. One is industry, A is industry, B, C, D are agricultural items. Mr. Basu in his commentary says this is a cut at federalism. This agriculture is exclusively state, but you have put trade, commerce, supply, etc. in list 3. Now, the scope of 33 vis-a-vis 24, 25, 26 has been very well explained in a Supreme Court judgment, SIEL versus Union of India.
No, that is under 369, it was held to be in concurrent list. Therefore, they brought it to the concurrent list.
No, what happened actually,
Under the,
your Lordship is right.
Under the
369
temporary powers,
yes,
even though it may be agricultural products, under the temporary powers, it was under the
Yes.
concurrent list.
yes, yes. What they did was, they created a legal fiction. They said for the first 5 years, although all these items are in the state list, they will treat it as if they are in the concurrent list.
That's first to give Parliament the power to legislate.
Yes. So now what happened is, they didn't want the whole, see, if.
So they brought some of those items in entry 33.
Yes,
Which is,
which are agricultural items,
Right.
which are agricultural items.
but they continued it in the concurrent list.
Now it's forever. Now it's forever. There's a very nice, very short statement objects.
Interestingly, raw jute was not in Article 369. No?
Sorry, my lord.
Raw jute was not in Article 369.
Only jute was there.
Was jute there?
One second. I'll just subject to memory. 1 second. No, jute is not there. Your lordship is right.
Of the subjects in clause A of Article 369 were not brought into.
No, not all, not all, not all.
Just these limited
Yes,
items.
yes, yes. Because, for example, my lord, cotton, woolen textiles, iron, steel have gone to Schedule 1 of IDR Act. So they are not in BCD, but they are in A.
Right.
They are in A.
Now, what does CL say?
Tobacco also not there.
Sorry.
No, my lord, tobacco not here. Not there. Sorry, my lord.
What does the judgment in CL say?
CL. That shows the interplay of 24, 25, 26 and 52. And they say that what is in entry 33 of list 3 is out of entry 52 of list 1. Yes. Lord, will be volume 5, page 2209, PDF pages 2217. 2217.
Right.
Lord, the initial facts may be slightly important. What was challenged was some molasses order, which was upheld by the High Court and Supreme Court confirmed it. Kindly come to page 2213.
2213.
Bench of 2 judges, 2213. I'll just read para 2 and 4. The appellants in these appeals have challenged the constitutional validity of Uttar Pradesh Ksheera Niyantaram Adhinayam, being UP Act 24 of 64, which received the assent of the President on so and so. The occasion for this challenge appears to have arisen on account of orders passed by the Controller of Molasses, Excise Commissioner UP, under Section 8 of the Act, read with Rule 22 dated so and so. Now, para 4. Under the said orders of the Controller dated so and so, different percentages of graded molasses were reserved for distilleries and industries based on molasses and alcohol in the state of UP. The reserve quantity under the said orders was required to be sold at prices fixed by the state government. Now, please come to page 2214. They expressly extract 18G. Now, my lord, since your lordship has got page 2214 at 18G, to save time, kindly note, it says regulation, supply, distribution, trade and commerce. There is no production in 18G. The word production is not there in 18G. So out of the 5 items of Entry 26 has 2, trade and commerce. Entry 27 has 3, production, supply, distribution. So 2 plus 3, 5. But here only 4 are there, whereas Essential Commodities Act Section 3, all are included. So the point is, even under the IDR Act, Parliament has not preserved to itself, even by notified order, they can't cut into production. So now please come to para 10, page 2215. They see the entries. Lordship will just note entry 8 was not there. Now please come to 11, they refer to Calcutta Gas. Now please see 12 and 14 are important. May I read 12 and 14? May I read? While dealing with entry 24 of list 2 and entry 52 of list 1, this court in the above case considered what was meant by the term industry, which was used in both these entries. This court held that in the first place, where whatever be the connotation of industry, it must bear the same meaning in entry 24 of list 2 as in entry 52 of list 1, because the two entries are interconnected, and giving differential meanings to the word industry in the two entries will snap their connection. This court further observed that ordinarily, industry was in the field of state legislation, but if Parliament makes a relevant declaration or declarations, the industry or industries so declared would be taken off the state list and passed on to Parliament. This court in that case was concerned with the interrelationship of 52 of list 1, entry 24 and 25 of list 2. The last entry expressly dealt with, your Lordship has seen that, I'll skip it. If we apply the same principle of harmonious construction to entries 24, 26 and 27 of list 2, the term industry in 24 would not take within its ambit trade, commerce or production, supply, distribution, which are the express province of 26 and 27 of list 2. Similarly, entry 52 in list 1, which deals with industry, also would not cover trade, commerce in or production, supply, distribution of the products of those industries which fall on entry 52 of list 1. For the industries falling in entry 52 of list 1, these subjects are carved out and put in entry 33 of list 3. Now please see 15. I'll just come to placetum E, my lord, below that. Just above placetum F. The products of the industry, Lordship has got it. The products of the industry would be comprised in entry 27 of list 2, except where these products were of a controlled industry, where they would fall within entry 33 of list 3. Therefore, the subject matter falling within entry 26 and 27 of list 2 would not be covered by entry 24 of list 2, and similarly, subject matter falling under entry 33 of list 3 would not fall under entry 52 of list 1. Murad, just I've done Murad, only one point. There is a controversy since your Lordship is sitting in 9 judges. What happens if a law is made but not notified? Suppose Parliament makes a law but doesn't notify it. Does it occupy the field? If a state law is there, will it be repugnant to that? Or there is a constitution bench judgment of Mar Aprem Kuri, where it says that the Chit Kuris Act, they made a Chit Act by Parliament, but it was never notified. So the constitution bench says law made by Parliament is different from commencement of the law made by Parliament. So just by making the law, Parliament occupies the field. My humble submission is that may not be correct, because Mr. Dwivedi also read, repugnancy must be in reality. So my submission is, unless the law is actually brought into force, the law made by Parliament must be the law made by Parliament which is in force. Lordship knows the Hire Purchase Act was made in 55 but never notified. Take service tax. 88th Amendment, never notified.
Section 2J of the Industrial Development.
Yes.
So to that extent, Mar Aprem Kuri, my lord, which makes a distinction between law made by Parliament and commencement of the law made by Parliament, may not be good law. Would the Lordship like to cite it, or I'll reserve it later, my lord. If we get time in reply, I'll mention that. Yeah, because I'm just submitting, because today what will happen is state has got the power in the new amendment. Portable alcohol fully comes within the state. Suppose tomorrow Parliament makes some law and doesn't bring it into force. The states can't be completely paralyzed or stultified. So I'm saying that the law made by Parliament will be a law only if it is brought into force. That's why Lordship saw in service tax, they added entry 92C, never notified it. So it is always under 97.
Right.
Deeply obliged.
Thank you, Mr. Patel.
Twenty 2012, 7 SC 106.